Hello, Dane Brooks here for EDU 503 Sports Law, Week 6.1 assignment, case study 6.3, Moore versus University of Notre Dame. This case was a little different, a little interesting. The case currently in the textbook was based off of a preceding case which took place on July 15th, 1998. The plaintiff, Joseph Moore, actually won a suit that he had filed against the University of Notre Dame, claiming that the university had violated the Age Discrimination of Employment Act when he was relieved of his head football coaching duties at the university for reasons that I'm not aware of because they weren't stated in this particular case. But he did win that injunction against the University of Notre Dame, and was awarded a payback settlement of $42,935.28, which was also doubled to cover liquidated damages. So for that particular case, he won $85,870.56. But Joseph Moore, he didn't stop there. He didn't think that was enough. The University of Notre Dame felt that that was much more than what he was entitled to, but Moore felt that he needed more, so he filed another injunction against the university, asking for reinstatement to the university and front pay. What front pay is, it is what the court summed it, let me find it, a lump sum representing the discounted present value of the difference between the earnings that Moore would have made while he was still at Notre Dame and the earnings that he is expected to receive in future employment. So basically what he was making at Notre Dame, what he could possibly make at another school or in another job. The difference in that is lump pay, or is front pay. Moore felt that he was entitled up to 5 years of front pay. His motion was for reinstatement and front pay. The court felt that reinstatement would not be a legitimate solution because of the volatile nature that and the volatile relationship that had become between Joseph Moore and Mr. Davey, his former employer. The court reinstatement is always at the court's discretion, and in this case, they ruled against reinstatement, but they ruled in favor of front pay. Just how much front pay was what was to be determined in this court case. The court determines the amount of front pay depending on whether or not there are four different things. The first one is that the plaintiff, in this case Joseph Moore, has a reasonable period prospect of obtaining comparable employment. Can he find another job at another university? Can he find another job equal to what he was making at the university? At this particular time, when this case took place in 1998, Moore was 66 years old, which is why he won the original case of the violation of the ADEA because of his age. Number two, the time period for the award is relatively short. Number three, the plaintiff intends to work or is physically capable of working, and liquidated damages have been awarded. Now, at the time, I guess, like I said, he was 66 years old. He has already found another job, so he is capable of working, and he was awarded liquidated damages. So, in other words, he had met all the criteria to receive front pay. Notre Dame, on the other hand, felt that Moore should not have been entitled to front pay because they felt that one, the award that he got plus the liquidated damages was enough to make him whole or to cover what he would have been losing had he finished out his contract at Notre Dame. Number two, that Moore had failed to make reasonable efforts to mitigate his damages or find another job. As I previously said, and I'll get to a little bit more here in a second, he has found another job. He is currently employed, but not making near as much as he would have had he kept his job at Notre Dame. And three, that in evidence that was acquired by the university after Moore had already been let go of his position, would have led to him being fired or let go in a legitimate, non-discriminatory way. The court, however, does not accept previous or acquired evidence after the fact, so that particular reasoning was completely thrown out. Notre Dame was convinced that the $85,870.56 was more than enough to cover his damages. The court did not agree, and all the evidence that Mr. Moore was able to bring to court and bring up against Notre Dame, the court was able to determine that he was scheduled to make $79,552.08 for the 96-97 salary on his contract, $82,734.16 in the following year, 97-98, and in the third year left on his contract, which before he was let go, he would have made $86,043.28. Not to mention all the benefits packages that he was losing out on too, health, dental, all that insurance benefits that he was losing. So the evidence that he brought did not bode well for the university. The court also found that the claims that Notre Dame's claims that he had failed to make reasonable efforts to find other employment was also incorrect as well, because, like I said, Moore, who was 66 years old, was currently working 3 jobs, bringing home an annual salary with all 3 jobs combined of $46,600. So the court did agree that Mr. Moore was indeed deserving of front pay. However, they did not believe that the 5 years that he was asking was reasonable. They felt that due to the nature and the relationship that him and Mr. Davey had, and that he would probably only have worked about another 2 years before retiring. So the court's ruling was in favor of front pay for Mr. Moore in the totals of $42,935.28 in back pay, $42,935.28 in liquidated damages. He was awarded $75,577.68 for the 2 years of front pay, which is the difference between his Notre Dame salary and what he's making now for his 3 jobs. The sum of that doubled by the 2 years that they said he would have worked. He awarded $9,672.45 in general costs and fees, and he was rewarded $394,865.74 in attorney fees and expenses. Altogether, with the violation of the act, which the court felt that Notre Dame was well aware of and that was done willfully, he was awarded a lump sum total of $565,986.43. It's hard to tell, if that's justified, because who's to say that he would have stayed 2 years? Who's to say that he wouldn't have made more? I guess you never know. He felt that at the age of 66, his chances of going to another university of that caliber, University of Notre Dame, and finding a position as a head coach was not possible. He had been offered other jobs at other universities, according to the case, but had turned them down, which the court felt he was entitled to. He's within his right. Again, I'm not sure how how I feel about it is quarter or $500,000 for a wrongful termination suit seems like a bit to me, but again, Notre Dame was found to be in the wrong, and knowingly in the wrong is what the Seventh Circuit Court basically filed their ruling on. So again, it was an interesting read. It was based off of a previous case, and I found it very, very interesting.